call the meeting to order, and as I think all members certainly know, we're dealing with clause consideration of Bill C-74. Before I start into the bill, does anyone have any problems if we stood Part 4 and Part 5 and started them at 3:30 tomorrow? We okay with that, and we'll deal with 1, 2, and 3, and then Part 6, Part 6, Division 1, 2, 3, and on today, and hold Part 4 and Part 5 till 3:30 tomorrow. There's no officials on Part 4 for today because they've got to come from Charlottetown. But if we could do it, we okay with that? Okay. Then we'll start. Then pursuant to Standing Order 75-1. Consideration of Clause 1, the short title is postponed, and we'll start with Clause 2. There's no amendments on Clause 2 to 12. Do you want to see those as one? And as clauses 2 to 12 carry on division? On division, okay. Clause 2 to 12 carried on division. In Clause 13, the first amendment up is CPC 1 by Mr. Kamish. Floor is yours, Tom.
Thank you, Mr. Chair. So this is based on some conversations I had with, and then some things I've read about a marriage penalty. So I'm just going to refer to the Joint Committee on Taxation of the Canadian Bar Association and Chartered Professional Accountants of Canada. In their appendix, they say that the relationship breakdown exclusion is too narrow, according to them. So in it, they kind of go into the details. And I'm not a tax lawyer here, and I'm not a tax accountant. So if there's a friendly amendment to make this work better, I'm just trying to get at the situation where there would be a breakdown in a couple's relationship, whether it's a marriage or a common law relationship. So I'm just going to read just a portion here. It says, in many cases where a couple involved in a family business separates, one of the spouses or common law partners will receive assets in his or her holding corporation through a paragraph 55(3)(a) spin-off transaction. In such arrangements, because the transfer of assets occurs between the operating corporation and the holding corporation, the spouse or common law partner will not have received property personally in a manner described in subsection 164. As a result, that spouse or common law partner will be unable to take advantage of paragraph B of the definition of excluded amounts, even though the economic substance of the arrangement is similar to a property transfer to the spouse or...
Slow down just a little bit, or the booth is going to wonder where you're at.
My apologies to interpreters. So basically, there's a description that continues on what the problem is. They go into also situations where inherited property exclusion in subparagraphs also won't apply. It's limiting parent-child, arm's length borrowings with no personal guarantee should be arm's length capital. It kind of goes on into it. So I thought that this amendment, the way it's structured, would avoid some of the issues and would be closer to what the joint committee of these two large organizations, so the Bar Association and the CPAs, have said would be a means of making it fairer in situations where there is a spousal breakdown and ensuring that the agreement by which they reach and the judge agrees to it would then be the way that they would be taxed. So again, if there's a clean, friendly amendment to make this more effective, I just think this gets at a fairness provision and making sure that the outcome is fair in situations where right now, as the rules are, they won't apply, and some people might get in a situation where they're taxed too much or taxed in a way that would be inappropriate. This would just be an easier way to plan the property settlement agreement through the court system. So that's kind of
I wonder if officials might have something to add, and I neglected to invite officials to the table. I believe Mr. McGowan, Mr. Lavoie, and Miss Lavoie, and Mr. LeBlanc are here to participate in clauses 2 to 46. So my apologies, folks. And I'm not sure if Mr. McGowan or others heard Mr. Comish's points. If you've got anything you want to add there, if there's any questions around the table, go ahead. Floor is open. Mr. McGowan.
Thank you, Mr. Chair. The proposals in Clause 13 of the bill operate within the general scheme of the Act relating to property transfers and the dissolution of a marriage and the breakdown of a marriage. In particular, there already is a provision in the excluded amount definition that relates to property transferred as a result of a dissolution of a marriage. It refers simply to subsection 160 sub 4 of the Act, which is the general rule that applies a general rule that applies in respect of property transferred on the dissolution of a marriage. It has within it certain restrictions, and those are consistent with the rules in the general scheme of the Act relating to transfers of property on a marriage breakdown. This amendment would seem to apply where property is transferred directly or indirectly, I guess, is acquired directly or indirectly by an individual, and also it seems to remove the requirement that they be living separate and apart at the end of the taxation year, which is in 160 sub 4. The general rules in the Act are designed to provide flexibility in the appropriate tax consequences on the dissolution of a marriage. There's a scheme, a coherent set of rules that operates under, very similar conditions so that things work well and appropriately together. The proposals in the excluded amount definition are designed to fit within that framework, and that's why they specifically reference the general rule in 160 sub 4 on transfers as a result of the dissolution of a marriage or common law partnership. It's not just on a marriage. And in addition, another rule was added in response to comments by the Joint Committee and others relating to the dissolution of a marriage or common law partnership, where at the end of the year, the two partners are living separate and apart. They would not be considered to be related for the purposes of the tax on split income. That was added after the December 2017 release and before the inclusion of the proposals in this bill. So that's another circumstance to ensure that couples who have split are treated appropriately under the split income rule. So if you're not related to somebody, then you won't be then you won't be in a position to split income with them, and then you're appropriately cut under the rules. So there are rules currently in the proposals dealing with the dissolution of a marriage or common law partnership. They exist within, and in the case of the deemed non-related status, go a bit beyond the current regime and the current set of rules that apply, and they were considered to be appropriate to to fit within how these I won't call them transactions, but these events are taxed generally for income tax purposes.
Dan.
Yeah, thank you, Mr. Chair. Just in regards to the other provisions relate to, you said that it relates to tenancy. If they're considered that they are still living together, that they are then considered part of the same, that relationship still exists. Is that correct?
I'm sorry, under this proposed...
No, I'm talking about the other part of the Act where you said that it refers to the dissolution of a common law or marriage, that it has to do with tenancy, though, that they are living together under occupancy, I believe?
I believe that one of the conditions for the application of 160 sub 4, which is the provision referenced in the proposals in the excluded amount definition, has the requirement that the couples be living separate and apart at the end of the year in order to qualify.
So just to state to my other colleagues that are here, and I'm sure many of you have come across in your own cases, I do know of individuals that are living separate but within the same household and have structured their affairs different. Anyway, I just would simply say that if someone had clearly, if the marriage was dissolved by a court order, but they were still living in the same house, so to speak, whether they be separated by a renovation or whatnot. To me, if a court was to be able to say they are living not in a common law or whatnot, I think that this would give that. They'd have to convince a court of law for that. Second part is that we also do know from my interventions before, both here and in the chamber, that there are single parents that will have a spouse or ex-spouse that will continue to file their taxes as their last place of residence, and usually it's a single mother can't get her Canada Child Benefit. So I think that what Mr. Kimmich here is suggesting, that if someone has a court order that says they are living, that they've dissolved that relationship, I think that that would be at least worthy of inclusion in this new arrangement.
Tom, did you want to add more? And then I have Jennifer.
Maybe I'll just close. So there are a lot of situations where separation is inevitable, and it will happen, but that might take, there might be 1 or 2, 3 tax years before it's resolved. So I think there's just a way to ensure that the financial assets that the couple had are broken down in a way that will ensure that they're at least financially whole, and if a judge agrees to it by decree or a competent tribunal, it says the amendment, it would be a means of ensuring, at least financially speaking, they would be made whole. The definition of 164 is too narrow according to this committee, and in an equalization arrangement, a spouse would receive a significant dividend potentially on a share that the spouse already owns, so that dividend will also not be protected by paragraph B. So it's too narrow in scope, and if you just broaden a little bit and allow the court to say yay or nay on this, it would just allow that space for individual situations that may vary. Like if you run a bakery and you have a holding company, an operating company, I understand what the rule changes are, and there's a marriage breakdown, that particular one. You're not talking about a lot of money. You're talking about maybe the business itself. You're talking about maybe a mortgage. It's just allowing a judge to have that latitude to determine what will be taxed and what wouldn't be, and under what conditions. I think it's just a way to ensure some fairness. So that's kind of the point of this.
Ms. O'Connell.
Thank you, Mr. Chair. While I appreciate the intention of the amendment, I think the issue is that you're actually creating another stream of an exemption or an exclusion to spouses and common law partners who live apart. And in the scenarios that were just presented, you will eventually get there when you're through court proceedings. But what you actually would do with this amendment is create exemptions for spouses or common law partners who continue to live together, and would raise, I think, tax integrity issues in the larger system. And as Mr. McGowan pointed out, this is a general principle that is used throughout Income Tax Act relating to marriage breakdown. So I think, while again I understand and appreciate the intention, I think you're actually creating bigger issues by exempting spouses and common law partners who still live together, and not keeping it consistent with the Act. So I won't be supporting this amendment.
Any further? Mr. Albus.
Yeah, I would just say that a court of law or tribunal would hear the evidence, and there are reasons why people will stay together in the same home, particularly if they renovate it, because many people cannot afford, thanks to a stress test or because of high rates for house prices, just to simply separate. And in some families, it's to provide stability for the children over the long term while a separation happens. So again, having a court of law actually differentiate who should be able to receive which asset, I think is actually quite helpful, because it removes the arbitrariness of CRA or the uncertainty that a tax planner or an accountant would have to give to their clients. I would just hope that other members would support it.
Any further discussion by anyone? Okay, on the CPC 1, all those in favor? Opposed? Lost. Okay. Still on clause 13, CPC 2. Mr. Kamish.
So thank you, Mr. Chair. So on this amendment, this was the more difficult one I found to draft. So I just want to thank the Legislative Council people. They were very understanding. And I'm going to speak slowly so the interpreters can follow along. So the scenario I'm trying to avoid here is the following. So if these new TOSI rules apply, the specified individual will pay the top marginal personal rate applicable to that income with no personal tax credits available. So the example I have is, let's assume there's a husband and wife who own shares in an operating company. And let's further assume that any dividends paid to the husband would attract TOSI, and both husband and wife are not in the top marginal rates of income, even if such dividends were received by the wife. Now, if the husband receives dividends from this operating company, he will pay the top marginal personal tax rate on those dividends as a result of the application of the TOSI rules, even though had the wife received those dividends on top of her actual dividends, so just the same person receiving all of it, the husband doesn't get anything in this scenario, she will still not have paid the top marginal rates. And I think that's unfair. So the scenario I have in my head is you have maybe a successful small micro business. It's a family business. Maybe they earn $100,000 a year. They have, say, just for the math to be simple, they have $20,000 of operating costs they set aside. This is a year when they want to pay themselves out and pay themselves some money. So the wife pays herself 60, and the husband, who attracts the TOSI rules, she wants to pay him 20. In that scenario, he's paying the highest marginal rate on the 20, but if she took the 80, the whole amount to herself, she'd have a lower rate than, so the combined taxes are actually higher in this scenario. And it's just an unusual way it kind of winds up. So I talked to Kenneth Kung, and I apologize if I butchered his last name, and Kim Moody at Moody and Gartner about how this would work exactly. And mentioned this amendment would get it to at least getting at that fairness concept, where if one spouse wants to, they're both working in the business, but one spouse is not active enough to avoid the new TOSI rules, you would have basically a situation where you could overtax a spouse that is critical to the business because they're supporting the other one. The business is not successful enough to make a huge amount of money to be like the real target, I guess, of these TOSI rules would be like the top 1%. These are just people making by, like I said, $100,000 a year in revenue, pretty reasonable example. But paying out one of the spouses at a smaller rate would then attract these new marginal effective tax rate, the highest bracket they'd be paying on those dividends. So the way I'm trying to avoid that unfairness that I see here. And again, if there's like a friendly amendment that would make this work better, this was a very difficult one to draft. I was told if I had drafted it in the original format, it would have been very long and almost an entire rewrite of that portion of the code of the Income Tax Act. So yeah, I'm just looking for a way to avoid those types of scenarios where we unfairly overtax one person in a spousal relationship who is contributing to the business, but not sufficiently to avoid the TOSI rules. In a scenario, basically, you're overtaxing them. So I want to avoid that type of situation.
Any further discussion? Mr. McGowan, do you want in here?
I'd be happy to go through, just from a technical perspective, the proposed amendment. So what it does is the charging provision for the tax on split income is in subsection 120.4 sub 2, and it currently, as was noted, applies the tax on split income at the highest marginal rate. That's defined in subsection 248.1 of the Act as just the highest personal income tax, or the highest percentage, in subsection 117.2. Which is where you have the different marginal tax rates. And it would make the tax on split income apply at the lower of the highest individual percentage and what's called the appropriate percentage. The appropriate percentage is defined in subsection 248.1, also looking back to the different marginal tax rates, and it's defined as the lowest percentage that's listed in 117.2, so the lowest of all personal income tax rates. So the highest is 33, the lowest is currently 15, and so the lesser of course, 33 and 15 would always be 15. So this would have the effect of applying the tax on split income at the lowest personal income tax rate, which would will have the create an incentive to split income insofar as it would ensure that any income that you're able to divert would be taxed at the lowest marginal rate, regardless of the tax rate of the actual income earner.
So would this get to what Mr. Commish called a fairness concept?
Well, setting aside kind of subjective and normative evaluations of what's fair, what it would do is ensure that to the extent that you're able to split income, that you're going to be taxed at the lowest personal income tax rate. So, for example, just to come up with a different example, if you have two married lawyers, each earning $800,000 a year, but working at different firms, if they engaged in planning to kind of cross-pay dividends to each other so that they'd be considered split income, they would have they'd cap their federal tax rate at 15% instead of the normal marginal rates that you'd expect to apply. This doesn't seem to that the fairness concern that was raised was something that we had considered in developing the rules or the amendments, and so I think the concept would be to apply it at the top marginal rate, but that's not unfortunately what this amendment would do. So instead of in the example, I forget the exact numbers, but I think the higher income earner had 60,000. Instead of looking at the rate applicable to their marginal income, it would simply apply the tax on split income at the lowest 15% rate.
Okay, and I believe Mr. Fergus was next.
Well, actually, Mr. Chair, the witness actually took the words out of my mouth as to what I want to explain. I understand what Mr. Commish is trying to achieve, but I'm afraid the amendments, frankly, all it would end up doing is making sure that the TOSI, the appropriate rate, would always be taxed, not the lower rate possible, which is not the intention of it. And for that reason, I wouldn't be able to support this, but maybe something that we can consider working on afterwards.
Mr. Commish.
Just while I have the experts here, because now I get to ask them,
Yep.
Is there a way then to amend this to get at this example, the easy one, just because the math is simple, of $100,000 a couple, 60-20, like in that scenario, that just doesn't seem fair to me, that if you're trying to pay out your spouse just because they're supporting you, being helpful, and for whatever reason, I understand you could just pay yourself $80,000 and just plan as a family. But is there a way to amend either this amendment or the act itself? Can you point me in that direction for future use that would get at this unfairness that I see? And I know it's a normative statement, but I think it is unfair that in a situation where you have like a micro business and you're successful, that you want to be able to pay out your spouse for the contributions they make to it.
Well, I think in general terms, if there's a policy decision that's taken by a government, it can get complex, but it's always possible to draft your way there. In this case, the government decided to maintain the tax on split income level at 33% to maintain the disincentive to splitting income, and then. To answer what I think you'd also asked, ways to avoid the tax on split income, it's worth keeping in mind that the simplest way to avoid the rules is that if you have family members involved in the business, to pay them salary instead of dividends, in which case you're not even in the realm of the tax of split income, you're just under the general rules for salary. And you see many business owners, in particular when they have minors or people under the age of 18 involved in the business, will just simply pay a salary.
Okay, we're ready for the question. All those in favor of amendment CPC 2, all in favor? Opposed? Lost. NDP 1 on the same clause.
Merci, Monsieur le Président, et
Thank you very much, Chair, and I will present the amendment. I move that on Clause 13 be amended by replacing lines 21 and 22 on page 18 with the following. Subsections 1 to 7 apply to the 2019 and subsequent taxation years. For the 2019 taxation, the Minister of Finance announced that these rules with respect to income splitting would be retroactive. We should have voted on a bill that implements rules retroactively. My amendment would mean that businesses and individuals who would be targeted by this particular change would have the time to adjust to 2019 and following tax years. That is the intent of the amendment, to allow everyone involved to have the time to adjust. You have an income tax provision that would apply retroactively, and therefore they're being forced to adapt to adjust to a bill that wasn't implemented. So this should therefore allow for the Income Tax Act to apply, but with the possibility of a period to adapt. And therefore, I say that it should only enter into effect in 2019 taxation. Thank you very much, Chair. I don't want to contest the concerns that have been raised by my honourable colleague. But the Minister of Finance announced in the 2017 budget that the regulations would apply as of 2018. The document that was published on July 18, 2017, indicated that these regulations would come into force on January the 1st, 2018, and would apply to that tax year. That would take effect on December 31st, 2018. It's precisely what was announced by the minister. I can't contest it exactly, but the minister was very clear on that matter. It was written black on white that these adjustments would begin for the 2018 tax year.
Amendment. I mean, we're already almost June. We haven't even passed the rules, and the government wants them to apply as of January 1st of this year. In other words, people are going to know exactly what the rules are in probably early July, and they will have to retroactively adjust their plans back to the beginning of January. That's not how good policy is done. Typically, you implement a tax change, particularly in the case of an increase, before it actually takes effect. In this case, we're making people live by laws that were not even in place when they took effect. So I think let's just, at the very least, the government could push implementation back to the beginning of next year to give family businesses the ability to plan ahead. Thank you.
Any further discussion on NDP 1? Mr. Alves.
Yeah, I just would like to follow up with what Mr. Polyev has just said, in that many small business owners, if they don't have access to proper tax planning or an accountant on an ongoing basis, will not know how these changes will affect their income tax. And to be switching it halfway through, because there still is the other place that this legislation has to go through, halfway through the year is not fair, particularly when we've heard witnesses that have come forward and said that CRA will need to have solid evidence if it's going to be able to face a challenge in tax court on these things. So entrepreneurs should have been given notice of these rules so they could talk with their accountants, talk with their tax planners so that they could arrange their affairs in a way that's tax efficient and fair, in a way that they could then show that their spouse or children have been working in the business on an active basis and that they can prove it. As we know, there are many small family operations right across this great country in British Columbia. 90% plus is small business. And I tell you what, many of them trust family members because they do infrequent tasks and may not necessarily record their hours. So I do think that the government has not been overly generous. In fact, to now be saying to people, here's the rules that you have to apply for January 1st, this late into the process, I think it would be better policy to give a bit of a reprieve. So I give my colleague in the NDP a nod. I disagree that the TOSI changes in general. I think this is going to make it so there are so many rules, and that many small business owners that do not have access to an accountant that can give them clear-cut answers will simply not split income, and that will see less and less investment in our small family businesses. So I'll be supporting this motion, although I have to say I do not support the new regime, just because I do think that the government did this all in haste and did not consider the many impacts to Canadian small business.
Mr. Duceau.
Merci, Monsieur le Président. Je remercie mes collègues.
I'd like to thank my colleagues who've supported my idea on public policy as being reasonable. I know with respect for my colleague, there were differences in terms of the time of the announcement for the legislation, but it was adopted by Parliament that implements legislation. There is a difference. Mr. Fergus perhaps has been living in the Ottawa bubble for too long. Entrepreneurs at home or elsewhere in Canada do not necessarily read on a daily basis the Department of Finance communiques that are put out there. My intent was only to afford them some latitude so that they could become cognizant of this new legislation and make the necessary changes, particularly when you talk about measures that require entrepreneurs to prove the number of hours that they allot to their spouse or child who works in the family business. They have to be convinced about the level of participation. So January 2018 doesn't give them a lot of time to prepare timesheets for the work done in a family business. I was hoping this could be adapted to the coming year so that everyone could adapt to the new change. We hope to inform the most people about this new rule.
Je tiens à noter, puis mon honorable collègue.
My honorable colleague knows very well that my riding is just on the other side of the river, so I really can't say that the national capital region includes Aylmer. It can't be otherwise. If there were one thing that many entrepreneurs and owners follow closely, it is what has been introduced by the minister as of last July. It was the subject of several discussions, of debate, of national debate. I believe that business people have followed the issues very well and followed the provisions and the measures presented by the minister. On several occasions, the minister was able to clarify. In fact, on many occasions, the minister was able to clarify the measures themselves and state that they'd come into effect in 2018.
For the government to implement in January tax changes that are legislated in July is worse than changing the rules in the middle of the game. It is actually like changing the rules in the middle of the game and then applying those new changed rules back to the beginning of the game. If you imagine a hockey game where at halfway through the second period, the ref comes on the ice and says, oh, the rules have all changed, but we're just going to have to freeze the game for a moment and watch the first period and a half to apply those rules backwards to all the plays that have already happened. That's what they're doing here. So families who have arranged their businesses according to the rules as they are written in the law today are then going to have to go backwards to the beginning of the year and apply these highly complicated rules that two top justices of the tax court say are going to be the subject of battle, and I quote, in courts. We're going to take this cobweb of complicated rules and apply it to people retroactively. The least we can do is just move it forward to next year, let people adapt, and hopefully mitigate the damage that it will cause to the family business.
Okay, all arguments in. All those in favor of NDP 1. Recorded vote. Recorded vote.
Mr. Fergus? No. Mr. Graywall?
No.
Mr. McLeod?
No.
Ms. O'Connell?
No.
Mr. Sabara?
No.
Mr. Aldis?
Yes.
Mr. Kinich?
Yes.
Mr. Poilievre?
Yes.
Mr. Dussault?
Wait. Amendment is lost. Shall 13 carry? It wasn't amended. Shall 13 carry? On division? On division. Clause 14, Amendment NDP 2 by Mr. Julian. Or I guess Mr. Dussault.
I won't move it. I would like to withdraw it after careful consideration.
You're withdrawing it?
Yep.
Okay. NDP 2 is withdrawn. Shall clause 14 carry? Well, if there's no amendments there is no amendments proposed from 14 to 18. Shall clause 14 to 18 carry on division? On division, agreed. Clause 19, PV1. The mover isn't here, but it's inadmissible in any event because it requires a royal recommendation, as I understand it. Do you have English there? And I'd better perhaps read into the record why. Bill C-74 introduces the Canada Workers' Benefit. The amendment attempts to amend the definition of adjusted net income to remove some income that would otherwise be included in the adjusted net income. As a result, the income would be lower and therefore allowing an individual to obtain more benefits. As House of Commons Procedure and Practice 3rd edition states on page 772, quote, since an amendment may not infringe upon the financial initiative of the Crown, it is inadmissible if it imposes a charge on the public treasury or if it extends the objects or purposes or relaxes the conditions and qualifications specified in the royal recommendation, end of quote. In the opinion of the chair and Ms. May, this is in relation to your amendment PV1. In the opinion of the chair, the amendment could impose a higher charge on the public treasury than the one envisioned in the bill. Therefore, I rule the amendment inadmissible. With that ruling, shall clause 9...
For a moment, Mr. Chair.
Pardon?
May I speak to the process before the committee for just a brief moment?
Okay, for just a brief moment.
All right. I was required to be here due to a motion passed by this committee. Many members of you may have forgotten about that. Identical motions were passed in every committee. And I have to explain that, Mr. Chair, I've had a moment to explain to the chair. Whereas in the normal parliamentary rules, I would have the right to present amendments that were substantive at report stage. This committee passed a motion that says I can't do that because I have an opportunity to present motions and amendments clause by clause in every committee. Now, while report stage can only happen once a day for any particular bill, clause by clause can happen simultaneously in many places. Today, I find myself called before the committees to deal with C-68, the Fisheries Committee, C-69 and the Environment Committee, as well as C-74 and the Finance Committee, all at the same time, all on the same day. So I have to apologize that I've been in and out. I need to, again, plead with individual members to consider, if you're asked to pass a similar motion, those of us who are re-elected at the end of the next election, this motion imposes an extremely arduous and unfair process on members of smaller parties. So while I would have liked to have spoken to this to support the evidence of the Canadian Labour Congress as to why the way the bill is functioning will unfairly reduce the Canadian worker benefit entitlement, I accept the Chair's ruling that it's out of order for the reasons the Chair has stated. But I did want to put on the record the reasons that I may not be here for one of my subsequent amendments because of the pressures of clause by clause in a simultaneous committee. I hope that this process of putting members through this, through the motions passed by every committee, will be reconsidered because it's extremely unfair. Thank you.
Thank you, Ms. May. So shall clause 19 carry on division? On division. There's no amendments on clauses 20 to 68. Do we have consent to go with well, I guess I'll put it this way: shall it carry on division? Shall they carry on division clauses 20 to 68? Carried on division. Then starting on tab, which would be part 2. Thank you, Mr. Officials, for coming. On part 2, part 2 from Finance, which is amendments to the excise tax, tobacco taxation, and related legislation. We have Mr. Colomb and Mr. Mercil from Finance. In case there's questions to you folks or clarifications. Okay, clause 68. We went to 68, didn't we? Yep. Okay, on clause 69, first amendment proposed is from the NDP, and we, just for clarification, Mr. Dussault, the vote on NDP 3 applies to NDP 4 as they are consequential. So that information is there. So NDP 3, the floor is yours.
Merci, Monsieur le Président. Et justement, j'allais mentionner que.
Thank you. You all have mentioned that this is the first of 2 amendments that are related. This is a subject that has been discussed often by this committee. It's this whole issue of taxation, excise tax on cannabis for medical purposes. I know that the committee has received many letters. Perhaps 4,000 or more Canadians have written to the members of this committee to oppose this new system, this tax regime on cannabis for medical purposes. It will have a very negative effect on current users, because it's a system that's already there, it's in place, and many users, more than 260,000 users, are using cannabis for medical purposes. They have openly criticized this new tax on the medication, to use the proper word. And if it is actually imposed, the excise taxes on the production of cannabis, including cannabis for medical purposes, would constitute taxation. To my mind, this is a definition to section 2, clause 2 rather, of the proposed legislation. There is a definition that is called cannabis drug, prescription drug. It is quite a limited definition, what exists in the legislation, outlining the conditions that have to be met to use cannabis for medical purposes, a mixture of drugs that could be sold to a consumer without excise tax. It would be considered a prescription drug, medication. And a prescription cannabis would be prescribed by a doctor. I'll come back to this later, but you would have to get a DIN, a drug identification number, that which is quite difficult and complex to obtain. You have to prove the effectiveness of this medication to obtain the DIN, and no cannabis used for medical purposes could obtain that until there would be years of trials and research. So my amendment would put in place a further definition. I don't mean to withdraw the one that already exists in the legislation, but it would be in addition to it. It's cannabis for medical purposes means cannabis that is intended to be sold for medical purposes under a license or permit issued under the Cannabis Act. That would broaden the definition in terms of excise tax on cannabis, and it would allow the producers, and we've heard evidence from producers who appeared here, that it would be possible for them ultimately to, in their production, be able to distinguish between what is cannabis intended for medical purposes and cannabis intended for recreational purposes. Producers are ready to make that distinction in their own production. Cannabis that is intended for the medical market could be exempted, and that's the second amendment that we'll discuss later. It could be exempted from excise tax because it's used as a prescription drug, a medication. And I'm very happy to see what, I'm very eager rather to see what the position of my colleagues around the table is with respect to this. It's not a sin tax here. Sin taxes apply to tobacco and alcohol. But this is about cannabis. It's okay for cannabis destined for recreational purposes, but here we are speaking about medical purposes. We have heard a lot of evidence from civil society, and many and several of my colleagues around the table would like to see a tax exemption for medical purposes.
Thank you, Mr. Chair. Thank you to my colleague for the amendment. I think at the end of the day, though, the excise duty does not apply to products, as you've pointed out, that have DIN numbers and or that are prescribed by a physician. And I think that's an important clarification because, for example, under the current system, doctors provide authorization, not a prescription, for medical cannabis. And I think moving forward that accessing a DIN number or going through the rigorous process and the trials to receive a DIN number is an important step in, I think, this country in ensuring that prescriptions and products receiving that DIN number are done so in the process that I think all Canadians come to expect in these types of products. So I think there is an avenue there, because I do think we'll get there one day in terms of cannabis producers for medical purposes will go through that process, and I think they should. And once they have the DIN number, then it is already built into the legislation that they would have the excise duty exemption. So I think that we're creating a system that is fair. I don't think we want to go down the road where people start arguing why certain products shouldn't have to go through the drug identification number process. So I'm perfectly comfortable that there is an avenue to be exempt from medical cannabis as long as they go through the process that I think other products have to go through as well. And moving forward, doctors can then prescribe it in the same manner. So I'm happy that there's a path to get there because, like I said, I think we will eventually get there. But it's up to those cannabis producers to go through the rigorous testing that I think all Canadians would expect, and then that would automatically kick into the existing legislation. So I won't support the amendment because I think that's an important step that should be taken in order to have this exemption.
Mr. Kamish.
I was just going to ask the officials, what would happen if this amendment is not done? Will there be a situation where persons who require cannabis for a medicinal purpose is prescribed by their doctor would then have to pay GST on it without this amendment? Like, I understand the whole din from Health Canada, but until such time as it's done, in the interim, will people who are obtaining, veterans who need to have a prescription for medicinal cannabis be charged GST?
Mr. Marcel?
The amendment that we're discussing right now doesn't touch at all the GST. Their amendment to the Excise Act 2001 that imposed the excise duty on cannabis.
But I'm talking about this, so, but if this amendment passes, will they be covered?
Whether this amendment passes or not has no effect.
There's no effect on it whatsoever.
On GST.
Okay.
And there's, just for clarification, that there's nothing in the consequential amendment NDP 4 that covers off this point either, is there, Pierre?
Non, ici, on parle vraiment des droits d'accise.
Oh, we're really talking about excise tax here under the 2001 Act. So GST and so on would be amendments 5, 6, and 7 that might deal with the current situation, which is that cannabis, as we speak, is taxed with GST and harmonized sales tax elsewhere in Canada. So it's like for the alcohol producers, as soon as they've produced a drop of alcohol, they're subject to excise tax, and that would be the same thing for cannabis producers because it's the same legislation. So we're adding cannabis to alcohol and to tobacco in terms of the moment of production and not retail.
The purpose of the amendment here is to create a definition in law so that there can be an exemption down the road. I think that's the pith and substance of it is, so I'll just take it as that. I just wanted to correct the good member here from the NDP, just that when I go to many Okanagan wineries, many of the people there will tell you that they are sampling the wines for their heart, for good health reasons. So I just don't like you lumping in alcohol as being a sin tax.
Very good point.
I know I'd get a laugh out of this one.
But that's just red wine, isn't it?
Yes. Well.
It's a good job we're not the Health Committee. Any further discussion on NDP 3? Hearing none. All those in favor of NDP 3? Recorded vote. Mr. Clerk.
Mr. Fergus. No. Mr. Graywall.
No.
Mr. McLeod.
No.
Ms. O'Connell.
No.
Mr. Sobara.
No.
Mr. Albus.
Oui.
Mr. Kimiech.
Oui.
Mr. Poliev.
Yes.
Mr. Dussault.
Oui.
Yes pour 4, nays contre 5.
Okay, NDP 3 is defeated, and as a result, we will not be dealing with NDP 4. Turning then to PV 2, Ms. May.
Thank you, Mr. Chair. Parti Vert 2, or Green Party 2 amendment, attempts to do the same thing that the NDP amendment attempted to do. At least I think it's in the same ballpark. Where my amendment comes in is in recasting, tweaking, if you will, the definition that appears just below of prescription cannabis drug. What I'm attempting to do here, and I hope it will be effective in ensuring that medical use of cannabis is not exposed to a GST, HST charge. And I appreciate the support down this whole side of the table. It's nice to be working with Dan Albus again. We worked on Free the Grapes. Maybe we can help people who need medical cannabis at the same time and get everybody on board. What I've done with this amendment is to say that prescription cannabis drug means a cannabis product that is intended to be sold for medical purposes in accordance with the Controlled Drug and Substances Act or the Cannabis Act or a cannabis product. This will get us out of the requirement of for a DIN, because we do know that according to testimony that was before this committee, there are 269,000 Canadians using cannabis for medical purposes on the authorization of their healthcare providers. But some of those products, very, very few of those products actually currently have a DIN, and many of them may not be able to get through all the hoops to do so. So this broadens the definition of a prescription cannabis drug to our real-life example of how such drugs are used right now. Thank you, Mr. Chair.
Ms. O'Connell.
Thank you, Mr. Chair. And my comments are going to be very similar as the last round, but at the end of the day, if these products, cannabis products, go through the process, the rigorous process of testing and get a DIN number, then they would be exempt from the excise tax, similar to other pharmaceutical or prescription drugs. So I think that it's not too much to ask that if you would like this exemption, then that work and that testing needs to be put in place. And again, I think it's important that there is a path towards this, because I don't deny that there is a significant use and purpose for medical cannabis, but I think it has to go through that process just like any other prescription drug. So it's similar to my last comments. Thank you, Mr. Chair.
Okay, any further discussion on this PB2? All those in favor? Opposed? Lost. Shall 69 carry? Carried on division. Shall 70 to 72 carry as there is no amendments on division? Clause 73 NDP4 has been set aside due to NDP3 losing, being defeated. NDP 5, Mr. Dussault.
Ouais, un peu dans la même
Well, in the same vein, if you will, this makes two changes to Clause 73 on page 60 in the English version at line 31 regarding the rights to produce cannabis. And this deals with the taxes that are imposed. And this would be drugs that are other than prescription cannabis. If you look at the original definition in the bill. So there is this imposition at the time of packaging. And so I'm looking for a replacement at line 31 on page 60. So on the imposition on those that are imported. And the other is replacing at line 27 on page 61. So once again, it's an effort to exclude those taxes on cannabis for all cases where we're talking about medical marijuana or medical cannabis.
So based on what I just heard, and I don't know if it's a translation, but based on what you, the amendment says, it's not all medical cannabis. It's specifically prescription cannabis, and duty imposed on a prescription cannabis drug is not payable under subparagraph 158.3 bracket A7 of the proposed amendments to the Excise Act 2001. Therefore, these amendments are not needed. So I think if you're, with all due respect to the chair, if your amendment was all medical cannabis, that's not how the amendment is drafted, and this drafting, based on the reading, is that prescription cannabis, as explained in the previous amendments, if it's a prescription, it would have a DIN number and would not be subject to the duty. So I don't know. I'm not going to support this amendment because it's redundant, and I think it's not really the intention of what perhaps meant to be drafted. But as far as it's written, it seems redundant because it would be covered already. It's my understanding, anyways.
Anybody else want in this discussion? Mr. Kamish.
I wanted to hear from the officials if they could comment on the impact of this amendment, and just a point being made on the government caucus side, that is this redundant?
Écoutez, je vais répondre simplement sur les mêmes lignes.
I would respond along the same lines as what the member said. Indeed, the taxes that are imposed are not imposed on prescription cannabis products. And under 158.31, small one, in the bill before you, the changes would not be necessary in order to achieve this.
Any other questions? All those in favor of NDP 5? Opposed? Lost. Shall clause 73 carry? On division, from clauses 74 to 94, there is no amendments, so shall clause 74 to 94 carry on division? Division carried. Okay, where are we at here? Clause 95, NDP 6. Mr. Dussault.
Merci, Monsieur le Président. Et maintenant,
Thank you, Mr. Chairman. And we are talking about the Excise Tax Act here. And also, it's a little different from the GST. And as I was saying about excise taxes earlier, here we're trying to broaden the definition, or in fact to ensure that all prescription cannabis products would not be taxed through GST and other taxes, other sales taxes across Canada, the country, which is particularly the case. And this is what the groups spoke out against, in particular, those who came and testified before the committee, because they were saying that sales tax currently is applied to cannabis. And this bill is intended to settle that situation. Again, we were talking about the definition that was provided in the bill in the 2001 Excise Tax Act. And in my opinion, it's too limited a definition, and that's what the witnesses said as well. The only cannabis that would be exempt from GST and other sales taxes would be prescription cannabis. And so therefore there would be a DIN number. And of course, medication isn't taxed in Canada, but that would mean that some people who use medical marijuana today would see sales taxes added to their bill on top of the price of the product. And of course, that means that the price of the product for medical purposes would be higher than normal if this bill was passed. And so I am proposing this in clause 95 at line 13 in the English version on page 678. So I hope I have my colleagues' support on this.
O'Connell.
Mr. Chair, again to Mr. Dussault, I think it's going to be similar to my comments earlier or on the previous amendment, but again, I think the wording around prescription cannabis in the amendment makes this redundant because if cannabis is prescribed, then it would have a DIN number and would then be exempt. And under the current GST, HST rules, prescription drugs would be exempt from excise tax and the GST, HST. So the key, once again, is if medical cannabis is prescribed, then these amendments are not needed. It's redundant. It's that prescription that is required, and in order to get a prescription, the product itself has to have a DIN number. And under the current regime, there aren't prescriptions for medical cannabis. They are, what's the wording? I used it earlier, but they are basically exemptions allowed through medical practitioners or doctors, but it's under the criminal code. But moving forward under this regime, a prescription would then come with the fact that the product itself has a DIN number, and then all those tax exemptions kick in. So this amendment, again, is redundant based on the wording of prescription cannabis because it would already be covered under both acts.
Mr. Dussault.
Je veux juste rappeler ma collègue.
I'd just like to remind my colleague, with all due respect, that medications are exempt from sales taxes in Canada. So if a cannabis product did have a DIN number, of course it would be exempt. But the problem is that today there are a great many cannabis products that have a DIN number, but it means that after this bill passes, there's no problem that exists with those. So that is to say, the people who have a prescription and will be able to get cannabis products are sometimes, with some products, paying a tax. So the number of cannabis products that have the number will just mean that it'll be the same situation after the passage of this bill. We will not have solved the situation, and that's why we need to broaden the definition to include all cannabis products when they're used for medical purposes.
Just on that point, I can understand, Mr. Chair, if that is the objective of the intention of this amendment, but that's not actually what the amendment says. The amendment says and cannabis products other than prescription cannabis. So you're actually not saying all cannabis products, you're actually saying prescription cannabis is the item that should be really exempt. So I understand the intention, but that's not the text of the amendment. And the amendment is specific to prescription cannabis, and prescriptions are exempt. So that's the difference, and if the intention is something else, then this amendment does not reflect that intention of all cannabis products. So I have to go on what's in front of me, and what's in front of me is redundant because it's only prescription cannabis.
Okay, all in, all done? On NDP 6, do you want a recorded vote?
Yes, please.
Recorded vote on NDP 6. All those in favor? Oh no, you're doing it.
Monsieur Fergus.
No.
Mr. Graywall.
No.
Mr. McLeod.
No.
Ms. O'Connell.
No.
Mr. Sobara.
Nope.
Mr. Albis.
Yes.
Mr. Kimich.
Yes.
Mr. Poliev.
Yes.
Mr. Dussault.
Oui.
Yeas pour 4, nays contre 5.
The amendment is defeated. Shall clause 95 carry on division? On division, shall clause 96 carry on division? On division, clause 97, NDP 7.
C'est la même,
It's the same goal here, just a few lines farther down from the last proposed amendment concerning Part 3 of Schedule 6 of the Act. And so it's with the same objective as what I said earlier, just to say that patients who are using medical marijuana should not be taxed.
I understand that it's with the same intention, but unfortunately it's written in the same way, which specifies prescription cannabis, which would, again, is redundant because a prescription, any prescription of cannabis would already be exempt from the GST, HST. So perhaps it's just in the drafting, it doesn't meet the intent, but it's the same language that makes it redundant.
Okay, any further discussion? All those recorded vote, go ahead, Mr. Clerk.
Mr. Fergus?
No.
Mr. Grewal? Mr. McLeod?
No.
Ms. O'Connell?
No.
Mr. Sobara?
No.
Mr. Albus? Yes. Mr. Kimiech?
Oui.
Mr. Poilievre?
Yes.
Monsieur Dussault?
yes.
Set aside.
Yes pour 4, nays contre 5.
Okay, defeated, shall clause 97 carry? On division? Okay, there's no amendments on clauses 98 to 119. Shall that carry on division? On division? And then we set aside clauses 120 to 199, I believe, just to be sure here, till tomorrow at 3:30. Okay. Then starting then Part 6, Division 1. 190, should it be 98 or 199? $198.198. We'd start with 199, right? One. Okay. Just find out where we're at here. 199 to 403. There's no amendments on any of those?
No.
We'll check in here to make sure we don't make a mistake, folks. There's no amendments on Part 4, the various divisions. I'll just go through them. Part 4, Division 1, there's no amendments. Part 6, Division 1, no amendments. Division 2, Canadian Deposit Insurance Corporation Act, there's no amendments. Division 3, Federal Provincial Fiscal Arrangement Act, there's no amendments. Division 4, Securities issued or guaranteed by foreign governments, there's no amendments. Okay. Here. We don't want to go back and then have to have a motion to go back. NDP 7 was the last, and then I don't think there's any. I think they all are on. Division 3, Federal Provincial Fiscal Arrangements and Acts, there's no amendments. Division 4, Securities issued or guaranteed by foreign governments, no amendments. Division 5, Exchange Fund Account, there's no amendments. Division 6, Banknotes, there's no amendments. Division 7, Payment Clearing and Settlement, no amendments. Division 8, Canadian International Trade Tribunal Act, there's no amendments proposed. Division 9, Canadian High Arctic Research Station and applications of an order in Nunavut, no amendments. Division 10, Canadian Institutes of Health Research Act, no amendments. Division 11, Red Tape Reduction Act, no amendments. Division 12, Communications Security Establishment, no amendments. Division 13, Department of Employment and Social Development Act, no amendments. Division 14, Employment Insurance Act, no amendments. Division 15, Judges Act, no amendments. Division 16, Financial Sector Legislative Renewal, no amendments. Western Economic Division 17, Western Economic Diversification Act, no amendments. Division 18, Parliament of Canada Act, no amendments. Division 19, Canada Pension Plan, no amendments. And that takes us to Clause 102. And I understand okay. Shall clauses 199 to 403 carry on division? On division. So, Part 6, Division 20, Clause 403. There's a proposed amendment from the floor, and there needs to be copies made. Okay, they have some? What's the amendment as to what section?
Section 404.
404. Okay. Shall clause dealing with clause 403, I see no proposed amendments in 403. Shall it carry on division? Carried. Clause 404. Mr. Fergus and then Mr. Fergus.
Thank you. Thank you, Mr. Chair. You'll just make sure that Mr. Dussault has his copy.
There's no need to rush.
Marvelous. Mr. Chair, I'd like to propose a simple amendment regarding clause division Part 6, Division 20, Section 404, Specifically, I'm referring to clause 71536, section 1, and subdivision A and B. I would like to amend it by replacing lines 1 to 11 and replacing them with the following, which reads similar. After an organization has accepted the offer to negotiate according to the terms of the notice referred to in section 715.33, the prosecutor must take reasonable steps to inform any victim or any third party that it is acting on the victim's behalf, that a remediation agreement may be entered into. It's to provide as much flexibility as possible, Mr. Chair, and for the members of the committee, to allow them to figure out whether or not that is an option that they want to pursue, or whether or not they want to continue along with the original prosecution. But the idea is to make sure that the third parties or the victim, or third parties acting on the victim's behalf, or the victim or her himself is informed that the prosecution is entering into these kind of negotiations.
Okay, who's up? Mr. Albas?
Yeah, thank you, Mr. Chair, and I certainly appreciate the spirit of which Mr. Fergus is trying to improve upon this. Obviously, I'm from a party where victims, we want to put them in the heart of the justice system. The unfortunate part about today's amendment is actually just further elaborates the concern I have with this government deciding that it would make large-scale changes through an omnibus bill. I have no problem with some of the compensation for justices or some of the other portions of the bill, Mr. Chair, but you've heard me say this before. We did not have substantive evidence from witnesses on Division 20. Many of us rose and expressed concerns, and Mr. Fergus included, about the whole process of including a large section or such a departure from the criminal code and putting it from this committee when we could not study it. I know that we have some lawyers either who are currently practicing or formerly practiced, but again, the Justice Committee would be the better venue, and considering that the government has Bill C-75 as well as other pieces of legislation, omnibus legislation, that it could have included to have a proper study done by the Justice Committee, where they could have brought in from victims groups to academics to to other groups that could come forward, whether they be from the legal side or otherwise, to basically argue whether or not this legislation is good or not. But I take issue that the government put a small section in their budget that applies what is more about restitution and how we process criminal proceedings or not in a budget bill. Now, people can take issue with the previous government on many different parts of it. I've defended actually the use of omnibus legislation by the previous government and this government, because sometimes you have to have a process to move things forward. But this is the wrong process. I heard from members of the NDP, Liberals, as well as our own caucus, that were quite taken aback by the government's approach. So I think that this is doubling down by offering an amendment. I certainly appreciate where Mr. Fergus is coming from. I don't necessarily disagree that including provisions to make sure victims are included, that's not the issue I'm taking with here, Mr. Chair. I'm taking issue with the fact that this Liberal government is putting through, without very much scrutiny, a wide departure. And I think it needs to be registered clearly. I think that this is wrong for the government to be using the Finance Committee process. If I can be corrected, I don't believe we heard from witnesses in direct reference to the Division 20, with the exception of an individual official from the government. So this has not been studied in the proper way. It has not been a proper process. and I am going to be voting against the overall process, Mr. Chair, because I don't think this is the right way for the government to carry this forward. Again, through the Justice Committee would have been a more ideal process, and for the government now to be introducing, we all had a timeline, Mr. Chair, of when we were supposed to have our recommendations for amendments in. To have this table dropped at this time, I have to ask to see if you, number one, is it in order? Because I don't think that that is a proper process. The rest of us work very hard. We don't have the government resources where we can call upon the Minister of Finance's staff or the Finance Canada's staff or the Minister of Justice and her staff to be able to advise on these things, and yet we can make a deadline. So I think the fact that they are adding these changes, Mr. Chair, in this committee after hearing very little evidence on Division 20, I think is troubling. I think it points to the government is running a haphazard process. I think Parliament suffers. I think that we should not support any further movements. In fact, this should be given to the Justice Committee, or if not, the government shouldn't proceed with this until a proper process has been done. They have other pieces of legislation, Mr. Chair, that they could have tacked this on that would have been far more appropriate than a budget bill.
The amendment is in order and allowing a fair bit of latitude here on beyond the amendment on Part 6, Division 20, that is Mr. Dussault and then Mr. Fergus.
Without repeating what my colleague has just said, I agree with what has been said by him. The version, the present version, and the proposed version, in both cases, they say essentially the same thing, but worded somewhat differently in a slightly different way. I'd like to have a bit more light shone on the proposed version. What precisely does it improve on the current version? I can say to my colleague that it allows a bit more flexibility, and it better sets out the context of the responsibilities of victims. This process will be considered, as we say in English, may be entered into. For those reasons, I would like to continue on with the wording of my amendment. Mr. Chair.
A couple of raised eyebrows over the language that was used just near the end of his comments. I'm just not certain if it's necessarily parliamentary or if it's something that we would want to. I'm certain of the member could express his point very strongly without engaging in that for the record, so that we don't make this a slippery slope in terms of using language which is less than parliamentary.
Don't think there was any non-parliamentary language here I'd have picked up. There was one strong word, but I don't think it was non-parliamentary. Mr. Commish.
I think I've heard off the record stronger things from the chair in the past. Off the record. It says under duty to inform victims. It says under duty to inform victims. I'm just reading the section one more time over. And I should mention that I mean the amendment may be in order, but there are no justice officials here to explain to us the impact of the amendment. So we don't even have the experts in the room right this minute, so that members of the opposition can at least ask them what they think. I don't see them here. I don't see anybody coming up to speak to this. And, you know, I am not a lawyer, so I would rely on them to explain to me the impacts of the amendment. The way I read the original section is I actually don't fully understand the goal of the amendment to the budget bill here. It reads to me like the victims are already looked after on a duty to inform, and it's as soon as practicable, and it kind of goes into it. We should be amending other sections, apart from the discussion Mr. Albus already said that we need to have. This whole section should have been cut out of this budget bill. It doesn't belong in an omnibus budget bill. So we got a fulsome discussion on how this interacts with the Magnitsky Act that was passed by the House unanimously. I think I was in this room when we were considering the amendments to the Magnitsky Act in a bipartisan fashion, and this whole section will have an impact on the implementation of that act and how companies interact with it. So in 715.36(3), the prosecution there can elect not to inform a victim or third party. If we were looking to ensure the rights of victims are looked after, that's the section we should have been amending, so the prosecutors are obliged to present the facts. And I'd just like to hear more from Mr. Fergus on what would be the impact and purpose of this amendment, because as it is right now, I don't see what this would do apart from deleting A and B in that section, and we don't even have the justice officials here to explain to us the repercussions of doing so.
I mean, this is a suggestion, and we didn't think we would get this far today in this bill. If you want to stand down these sections that relate to Division 20 until tomorrow, we can do that and have the justice officials here. That's entirely up to the committee. That would mean we would deal with Part 4, Part 5, Part 6, Division 20 tomorrow. Okay. So, I mean, that's possible to do if there's agreement from the committee to do it. Is there agreement to do that? I think that's fair. We really should have officials here on those three parts. So then, that really concludes all we can do today. And tomorrow we will deal with clauses 120 to 198 and clauses 403 to the end. And the other regular motions that we would have to do. So are we okay with that? Then meeting adjourned until tomorrow at 3:30.